be appointed to escort Chief Justice Stephen R. Jensen to the rostrum.
Comments on that motion? Hearing none, all in favor will say aye. Aye. Opposed, nay. Motion carries. President announces such committee is Senators Melhoff, Perry, Larson, Smith, and Wheeler, and Hulse, and House members Representative Lems, Odenbach, Overweg, Healy, Emery, Stevens, and Soy. Well, ladies and gentlemen, it is again my pleasure to introduce the speaker today, the Chief Justice Jensen. Chief Justice Jensen was appointed to the Supreme Court in 2017. He was selected by the Associate Justices to serve as our Chief Justice in 2021, and he was just selected again to serve as a Chief Justice for another 4-year term. Chief Justice Stevens grew up as a farm kid in rural South Dakota and attended the University of South Dakota School of Law. Chief Justice Jensen has served as a chair of the UJS Presiding Judges Council and president of the South Dakota Judges Association, and has served on other boards and commissions. The chief believes in equal justice for all and equal access to the court. It is my privilege once again to introduce Chief Justice Jensen to deliver his 5th State of the Judiciary address. Sergeant at Arms, would you please announce the arrival of the Chief Justice?
Would all of us please welcome Chief Justice Stephen Jensen, Chief Justice of the South Dakota Supreme Court.
Thank you. It's great to be here this morning. Governor Noem, Lieutenant Governor Roden, members of the legislature, constitutional officers, my fellow justices, judges, Unified Judicial System employees, and all South Dakotans, I am honored to deliver my 2025 State of the Judiciary message to you. And I might note as I get started, Lieutenant Governor Roden gave me he says he's got a time clock, and I've seen him weld the gavel in the Senate, and I hope he doesn't have his new baseball bat with him. With that said, I count it a privilege to have this opportunity each year to discuss the work of the courts in South Dakota. The importance of the work in the courts in maintaining peace and tranquility in our communities can often be taken for granted until we step back and take a brief look at history. A few months back, I was provided an excerpt from a book written back in 1947 by former Aberdeen School Superintendent Charles Darthorpe. He was one of the founders of the South Dakota Boy State program. In a section on the South Dakota Judicial Branch, Darthorpe describes how communities handled disputes and punished crimes before the courts were in existence in South Dakota. He states, quotes, "In the days of the early settlement in South Dakota, no courts were available. If a person was accused of a crime, he was taken before a citizens group, and both sides of the question were heard before one of the group, who was elected as judge. After the evidence was completed, a decision was made on the case without reference to law or logic. At times, when the crime was a serious one, like murder, rape, or horse stealing, the citizens did not go through the formality of a hearing. They merely shot the accused or hanged him from a tree. Clear-thinking and law-abiding early citizens realized that if the state was going to grow and prosper and attract high types of citizens, not sure what he meant by that, A good system of the courts must be established, end quote. The citizens of the territory that would later become South Dakota may have very well been well-meaning in their zeal to maintain order and seek justice, but a society based on mob rule will have a short and turbulent existence. We can be grateful that the founding fathers of the United States and the state of South Dakota recognized the necessity of due process of law and the importance of an independent judiciary designed to resolve disputes fairly, peacefully, and sensibly. For more than 135 years, the courts in this state have peacefully resolved factual and legal disputes that litigants have been unable to work out on their own. In county courthouses across South Dakota, the courts provide a fair and impartial forum for these disputes, where the rule of law is applied equally and consistently to all persons. This only happens through an independent judiciary that is not swayed by politics, power, or public opinion, but rests each decision on the established principles of law governing our decisions. When I was a circuit judge, many mornings I would walk into the courthouse and think about the awesome responsibility and trust placed in me as a judge to decide the cases that would come before me that day. I still feel that way as Chief Justice. Some of the cases can be resolved quickly, while other cases require a great deal of time, effort, and study. Regardless of the complexity of the case, every decision is weighty because it's always important to that person appearing before the court, and the result often has a significant impact on their life. The courts are not merely institutions of law, they are the bedrock of justice. They fairly resolve disputes between parties, determine guilt or innocence, and mete out an appropriate sentence. They safeguard our rights, uphold our freedoms, and protect citizens from governmental overreach. For these essential functions to be effective, however, they must be trusted. Trust is the foundation upon which the legitimacy of our judiciary rests. A person seeking redress in the courts needs to have confidence that the system will work for them. When a case is finished, a litigant should believe that they received a fair shake, regardless of the outcome. The public must also have confidence in the decisions and work of the court. When the public trusts the court system, they respect its legitimacy and authority, cooperate with the legal process, and participate in civic duties like jury service. Having worked in the legal system my entire career, I have a deep and abiding belief in the integrity of our court system in this state. The judges and court staff are not perfect, no human is, but they work hard to provide fairness, efficiency, and competency as they resolve cases. They are unsung heroes who understand their role in serving the public and providing access for everyone entering the courts. Nonetheless, we cannot take public trust and confidence in the courts for granted. Each of us working in the courts must daily recognize the need to earn and safeguard the public trust for the work that we do. And this can be difficult in the current age where trust in most institutions are at near historic lows. The rapid spread of misinformation, the divisive nature of public discourse, and the perception of bias and partisanship in our society all have the potential to erode confidence in the judicial system. The good news, however, is that according to a recent national survey conducted by the National Center for State Courts, nearly 2/3 of Americans have expressed trust and confidence in the state courts. Perhaps even more encouraging is that the percentage of respondents expressing trust in the state courts has actually increased slightly in each of the last 2 years. I really believe part of the reason for this encouraging trend is the close connection that exists between the citizens and their local state courts. People actually see how the state courts work and understand firsthand how the work of the courts positively impact families, communities, and public safety. To ensure that we continue to do this work well in South Dakota, the UJS this past year began a strategic plan initiative designed to develop priorities for carrying out the core function of the courts, and that is deciding cases fairly, efficiently, and competently under the law. The strategic plan is focused on access to justice issues, effective court operations and systems, our workforce, technology, security, and public trust and confidence in the courts. I want to speak to a few of these priorities this morning. Access to the courts has been a major focus for us the past few years and will continue to be as long as I'm Chief Justice and thereafter. We must, as a court system, do our best to ensure that every person in every case has an opportunity to be heard. This is the essence of due process of law. The early American statesman Daniel Webster defined due process as, quote, a law which hears before it condemns, which proceeds on inquiry, and renders judgment only after trial. The constitutional right to due process exists whether an individual has been charged with a crime or is seeking access in the civil cases to the courts. Access issues may look different in criminal and civil cases, but our obligation as a court system remains the same: to provide due process and fairness to every person involved in the court system. One effort that we have been engaged in to ensure due process of law in criminal cases is centered on our indigent defense system in South Dakota. Indigent defense is the constitutional right of every person charged with a crime who is unable to afford an attorney to be appointed counsel at the expense of the state. The Sixth Amendment right to counsel for those unable to afford an attorney is important to all South Dakotans and furthers public trust and confidence in the courts. Maintaining a strong system of indigent defense is what really makes us different from many other countries where the rule of law is not respected or upheld. The commitment to an effective indigent defense system not only ensures adequate representation for the accused, but also makes certain that our standards for due process are truly maintained. We are grateful that the legislature this past session enacted legislation offered by the UJS to create a commission on indigent legal services to oversee the delivery of indigent legal services across South Dakota. The commission is an independent body responsible for coordinating and managing the indigent defense system, developing standards for assigning and handling court-appointed criminal cases, and providing training and assistance to lawyers handling criminal appointments. The board is made up of a group of volunteers of experienced legal and governmental professionals appointed by the governor, the chief justice, this legislature, and the counties. The legislature also provided $1.4 million in ongoing funding to create the Office of Indigent Legal Services. The commission and the office will continue to be instrumental in taking an ad hoc system that has been county funded and managed and turning it into one that provides management of an indigent defense system statewide. The creation of the Commission and the Office of Indigent Legal Services is a monumental first step to create a more efficient and effective system of indigent defense in South Dakota. I'm pleased to report that the Commission's work is already underway. The Commission members have selected USD Knudsen School of Law Dean Neil Fulton to serve as chair. They've been meeting regularly since May to tackle the process and standards for statewide indigent services. Chris Miles, an experienced public defender and appellate lawyer, was hired by the Commission as the chief defender to run the Office of Indigent Legal Services. The office will initially be responsible for providing court-appointed legal services in appeals of criminal cases, habeas corpus cases, and abuse and neglect of children. The Office of Indigent Legal Services is designed to function very much like the Attorney General's Appellate Division, which handles criminal appeals in the state. We project that the efficiencies and expertise developed within the Office of Indigent Legal Services will save approximately $600,000 per year as compared to our prior system. With these savings and the state-funded office, we expect counties will cumulatively realize more than $2.1 million in savings annually. Last session, the legislature also authorized a one-time $3 million appropriation to counties to defray the cost of indigent legal services. The next and final step in moving from an ad hoc, county-funded and managed indigent defense system to a statewide system will involve implementation at the trial court level. Right now, we only have those services at the appellate level. Judges and counties continue to struggle, especially in rural areas, with finding attorneys to defend criminal cases. This is especially true in the most serious felony cases. These cases require experienced counsel who have tried cases on many occasions. Most often, serious felonies are handled by private counsel who may spend months defending these cases with limited resources and support. Additionally, in rural counties where there are few attorneys, it may be necessary for a private attorney to drive several hours to either meet the defendant in jail or to attend court, and their travel time is not currently compensated. The creation of regional full-time public defenders through the Office of Indigent Legal Services could alleviate many of these concerns, both in high-stakes cases and many other felony cases. The expansion of the Office of Indigent Legal Services to the trial court level will require statutory authorization from this legislature. And the funding of the regional public defender positions will need to be worked out as between the state and counties as we move forward. But we now have the framework in place to expand these criminal legal services to the trial courts throughout South Dakota. I want to emphasize this point that these changes are not going to involve any new governmental services. Indigent defense is already being funded by the South Dakota taxpayers. Rather, the changes are designed to replace an antiquated and inefficient indigent defense system managed and paid exclusively by counties. Moreover, the changes will ensure that South Dakota continues to meet its constitutional obligation to provide effective representation to the accused. This past year, the UJS asked the Sixth Amendment Center to assist in helping to implement some of the statewide efforts moving forward at the trial court level. They conducted an extensive review of 7 counties across the state to look at indigent defense services in those counties. Following the study, the Sixth Amendment Center released its report, making several recommendations and emphasizing the need for uniform standards for indigent legal services across the state. Significantly, the Sixth Amendment Center's report referenced a South Dakota study that was conducted back in 1977, which made nearly the exact same recommendations to ensure the constitutional right to counsel in South Dakota. I'm grateful to the legislature and Governor Noem for working with the judicial branch to accomplish this first step in a task that is truly 50 years in the making. Access to the courts in civil cases is another priority for the UJS. Recent studies have suggested that as many as 80% of civil cases filed in state courts in this country involve at least one self-represented party. We are seeing similar trends in South Dakota. The uptick in the number of unrepresented litigants in civil cases is a product both of the cost of legal services and the absence of lawyers available to handle civil cases. This is a trend both in South Dakota and nationwide. The number of self-represented litigants presents challenges for the self-represented individuals themselves, as well as for the entire court system. Self-represented litigants face difficulties understanding the legal jargon, the rules of procedure, and the substantive law which impact their case. Court staff, which cannot provide legal advice, but they're often asked questions about the documents that may be filed and the process for making a claim or asserting a defense. The additional time of court staff to review documents and answer questions places more demands on employees already managing full caseloads. Furthermore, judges hearing cases with self-represented litigants often are placed in the difficult position of maintaining their neutrality while ensuring that individuals are heard and able to present their case. Self-represented individuals may inadvertently slow down the proceedings as well due to their unfamiliarity with the court procedures and create more congestion as judges work through their busy dockets. Legal aid organizations in South Dakota, such as East River Legal Services, Dakota Plains Legal Services, and Access to Justice, offer free and reduced legal help for low-income eligible persons. And you may have seen when you came in today the Justice Bus, which is essentially a mobile law office that Dakota Plains Legal Services is able to take into rural communities and provide legal services where there are no lawyers. Unfortunately, the demand for these legal services in civil cases far exceeds their resources. These organizations receive on average 350 applications for assistance a month. Additionally, many individuals do not meet the income guidelines to qualify, leaving a gap for people who cannot afford counsel but are not eligible for legal aid. To better address these challenges, the South Dakota Supreme Court adopted a rule this past February to create a commission on access to the courts. The commission is comprised of 11 members representing the courts, the state bar, USD Law School, and legal aid organizations. The commission's work will include recommending improvements in court processes, developing legal forms and documents, improving resources for legal aid, creating models to assist self-represented litigants, utilizing technology, and recommending rule changes to improve the availability of legal services throughout the state. This work is still in its infancy, but I am excited about its prospect. I greatly appreciate the work of Commission Chair Judge John Saun from Sioux Falls and the entire commission as they work to improve access to justice in civil cases and enhance public trust and confidence in the courts. Probation services is another focus of our strategic plan in South Dakota. A court may impose probation with conditions as a part of a suspended county jail or prison sentence. Within the UJS, probation services are managed by court services. Court services officers oversee both adult and juvenile probationers, ensuring compliance with court-ordered sentencing conditions and facilitating rehabilitation efforts. It is important to distinguish probation from parole. While probation is a court-ordered sentence involving a period of supervision, which is part of a suspended sentence, parole involves a conditional release after prison sentence is served and is administered by the South Dakota Department of Corrections, not the UJS. During fiscal year 2024, UJS court services officers supervised 7,469 adults and 1,490 youth on probation. The dedicated efforts of our court services officers to provide supervision and connect individuals with the appropriate community resources and support in their path toward success, as well as accountability, are both demanding and deeply rewarding. Judges and court services alike can share countless stories of individuals whose lives have been transformed and have become productive members of society when they have successfully completed probation. This past fiscal year, a total of 1,780 adults and 1,038 juveniles were successfully discharged from probation. Before I talk about some of our efforts to enhance probation, I want to share with you just a few examples of some of the impactful work being done by court services in our communities. First individual is Danica. She was supervised by court services between the ages of 14 and 18. She struggled with alcohol and drug addiction. She spent 2.5 years on probation under the supervision of CSOs Tim Moon and Jennifer Groper from Mitchell. During this time, Danica worked to overcome her addictions as well as challenges relating to her family history, peers, and socioeconomic barriers. While on probation, she focused on accountability, sobriety, personal growth, and goal setting. She addressed many of the causes of her addictions and developed coping skills. Now, as an adult, Danica is a strong leader, a devoted mother, and a good role model for her community. She was recently named Miss Mount Rushmore last May and is a Miss South Dakota SLICC ambassador, where her advocacy work is centered on sobriety. Danica explained, I go around different treatment centers and I speak and I tell my story. I share my experience. It's not about where you've been, it's about where you're going. Another example is Corrine, who was arrested in July of 2023 by South Dakota Highway Patrol Trooper Troy Archambault for possession of controlled substance. She was subsequently sentenced to a suspended sentence with probation and has successfully been supervised by Court Services Officer Nicole Penrod. On October 15, 2024, at the Hughes County Courthouse, Corrine paid tribute to Trooper Archambault and CSO Penrod for saving and turning her life around. She presented both with a star quilt. Corrine told CSO Penrod early in her probation that she felt like the trooper that had arrested her had saved her life. She has earned 3 more credits toward her online degree at St. Galiske University and is seeking employment. Corrine's relationships with her children and family have been restored, and she will be discharged from probation shortly. Finally, I want to share the story of Chris, who was arrested at age 14 for truancy, second-degree burglary, breaking and entering, and alcohol consumption. As a high-risk, high-need juvenile, Chris spent ages 15 to 16 under the supervision of CSO Amy Wiglin. With CSO's Wiglin's support and help of community services, Chris overcame substance abuse, family and social challenges, and anger issues. Today, at age 26, Chris has served in the U.S. Armed Forces and on active duty. He is pursuing a career as an electrician and aspires to become a business owner. CSO Wiglin works closely with treatment facilities, juvenile services center, and counselors to ensure juveniles are getting the services they need. When she reflects on her work, she says, "I feel juvenile delinquency and high-risk juveniles are often a product of their environment. I feel we can offer all the services we have to juveniles, but until a family unit and community is invested, we will have limited success. We have many parents who are addicts, lack parenting skills, have mental health barriers, financial barriers, or legal barriers themselves, and who would prefer the juvenile to be removed from the home." I want to take just a moment today to express my thank you to these 3 CSOs I've highlighted for their work and their supervisors who are here this morning. And if you'd all stand, if we can express our appreciation to them. And Trooper Archambault is also with us this morning. And I would just tell you from my experience, it's not every day that an arrestee credits an arresting officer with saving her life and then gives a star quilt as a thank you gift. And I think that speaks to Trooper Archambault's professionalism and work as a trooper. So Trooper Archambault, if you'd stand to be recognized. And finally, thank you to all law enforcement and CSOs across South Dakota for their critical work in supporting public safety and efforts to assist individuals working toward rehabilitation. These individual stories highlight just a few of the hundreds of individuals who have successfully completed probation each year. Their stories also underscore the fact that many of these offenders are juveniles or young adults. In 2023, the UJS sponsored legislation to create an emerging adult task force to examine barriers to services for adults aged 18 to 25 who are involved in the justice system. The purpose of the task force was to explore opportunities to improve services and reduce recidivism. In addition to training focused on rehabilitating young adults out of the work of this task force, we've also begun work on several pilot projects. While these programs are in their early stages, we believe they have the potential to be successful in keeping young offenders out of further involvement with the justice system. There are more opportunities for enhancing probation services for juveniles and young adults as we consider expanding mentoring and providing safe housing to support individuals working toward restoration. For these types of services to be successful, we need to engage community volunteers, groups, and churches to walk alongside these young people. And we're going to begin work on this aspect of probation to see if we can get more assistance from communities, because this is not easy work, and it takes all of us to be able to accomplish the work of overcoming addictions and life-controlling obstacles for many individuals that come into our court system. Another way to improve rehabilitation outcomes is through enhancing services individuals receive before trial, not just afterward. Pretrial services assist people who are charged with crimes and awaiting a court date. CSOs can help gather and present information about newly arrested individuals and available release options to be used to determine what, if any, conditions should be put in place prior to their supervision. These individuals on pretrial services can also receive supervision as they are released from custody. We can monitor their compliance with release conditions and connect them with rehabilitative services. These services are all aimed at keeping our communities safe while ensuring that these individuals appear for their scheduled court dates. Some larger counties, such as Minnehaha and Pennington, have already introduced limited pretrial services programs to assist those individuals at the pretrial stage of the criminal justice system. The services available through these programs include assistance with completing information for the judge, offering court reminders, overseeing pretrial check-ins, and other duties as needed to support this phase of the justice process. Both counties have received grants to help fund these programs through their respective sheriff's departments. Pennington County recently secured an additional grant for a pilot project to further explore pretrial services program provided by Court Services. The two main goals of the program are to ensure that individuals attend their court dates and that they do so without further contact with law enforcement. We are currently conducting 4 site visits as a part of this grant that was received in other states that have implemented pretrial supervision in their communities. A statewide pretrial program will not take the place of anything currently happening in our justice system. It is intended to be an additional tool available to courts that does not currently exist. Judges make bond decisions every day in criminal cases, determining whether an individual is a flight risk and whether they can safely be released in the community prior to trial. Often, judges place conditions on individuals released on bond, but currently we have limited ability to ensure those conditions are being followed. Pretrial services will provide necessary supervision for individuals released on bond and create opportunities for collaboration with counties and prosecutors to develop diversion programs, which counties do not have the resources to provide at this time. As we think about moving forward with this project, it is important to note that the South Dakota judicial system does not currently have statutory authority to monitor adults prior to conviction. We anticipate offering legislation to create this authority. We will continue to work with counties, state's attorneys, public defenders, and community partners for their assistance and input as we work toward potential implementation of pretrial services programs in South Dakota. As a part of the UJS's work, both in the courtroom and through probation services, South Dakota's treatment courts provide enhanced opportunities to address addiction and mental health issues. Individuals with mental health issues who are struggling with addiction to alcohol or drugs commit crimes at significantly higher rates than the general population. Unfortunately, these issues are also some of the most difficult to rehabilitate. South Dakota's 17 treatment courts, which include drug, DUI, veterans, and mental health courts, play a vital role in addressing these issues. Treatment courts provide a long-term program with intensive supervision by the treatment court team, focused on and addressing some of the underlying causes of the criminal behavior. Treatment courts also help to reintegrate participants back in society and have been shown to significantly reduce reoffense rates as compared to traditional justice methods. South Dakota treatment courts have served a total of 2,684 participants since inception. Of these, 1,227 individuals have successfully completed the program, achieving a graduation rate of about 57%. We exceeded projections for admissions in fiscal year 2024 by serving 809 participants this past year, significantly more than the 698 anticipated, and a 21% increase from the 669 served in fiscal year 2023. The average length of treatment court program is 491 days. The average age of treatment court participants is 35, and the most common addictions are to alcohol and methamphetamine. The future looks much different for those who have successfully completed a treatment court program. These individuals experienced increased stability, benefiting from access to housing resources, financial counseling, and improved employment opportunities. They achieved better physical and mental health through consistent treatment, therapy, and healthcare services. This results in fewer emergency room visits and reduced long-term healthcare complications. Many participants pursue GEDs or vocational training with a greater likelihood of completing higher education. Through counseling and behavioral changes, they repair and strengthen family relationships, often regaining custody of their children. Structured payment plans and financial management support enables participants to meet child support obligations more effectively. Additionally, sobriety and prenatal care programs reduce the likelihood of drug-affected births and improve maternal health outcomes. The human condition and free choice create complexities that services alone will never fully resolve. But probation and treatment courts can and do play a significant role in helping individuals turn their lives around. Our role as a court system in helping to rehabilitate individuals is ultimately about providing the most effective services possible. We will continue to make this our mission every day. Courthouse and judicial security also remain important priorities for the UJS. The necessity of this commitment is underscored by the 56 threats and incidents reported by UJS judges and employees over the past year. Our effort to improve courthouse security across South Dakota has involved a three-prong approach. The first prong is the creation of local courthouse security committees made up of court, county personnel, as well as law enforcement. We have committees now in 51 of the 63 counties where courthouses are located in South Dakota. The second prong involves conducting security assessments by Homeland Security and the U.S. Marshals Service to identify potential security gaps at courthouses in the state. These assessments are done without any charge to the court system or the state. To date, 56 site assessments of courthouse locations have been completed. These assessments help guide the third prong of our courthouse security initiative, which is to use the use of grant funding to assist counties to implement recommended security improvements at courthouses. The grants are available as a result of the legislature's one-time $5 million appropriation 3 years ago, enabling the UJS to work with counties to improve security at all of our courthouses. The UJS administers the grant program, and the grant pays for 75% of the needed security upgrades at our courthouses. Over the past 2.5 years, this funding has significantly enhanced security at many courthouses in counties across the state. This past year, nearly $900,000 in courthouse security improvements were approved for projects statewide. Improvements have included installing camera systems, alarms, security doors, and upgrading courthouse lighting and parking areas. Two upcoming projects are a complete access control system for all 63 doors and the 2 elevators in the Pennington County Courthouse, and the construction of a new security checkpoint at the entrance of the Brown County Courthouse. The UJS will continue to utilize data and security incidents and site assessments to determine security gaps and seek future funding from the legislature as needed for ongoing security efforts and enhancement at our court facilities. Unfortunately, judicial security must also extend outside the walls of the courthouse. Over the past several years, judges and families across the country have been threatened, shot, or killed in or near their homes. I recently had the opportunity to hear Texas District Court Judge Julie Koceric tell her story of being shot multiple times in her driveway as she and her son were returning from a Friday night football game. The gunman targeted her solely because he was a defendant in a criminal case before Judge Koceric. After months of rehabilitation, Judge Koceric returned to her work and continues to serve today. Her story is a reminder of the risk that judges face every day. The UJS continues to work on enhancing personal judicial security through threat monitoring. We have also taken steps to safeguard judges' personal identifying information and made those services available to employees at reduced cost. The court system's work that I have described today can only be accomplished through the many dedicated judges and court employees of the UJS. Facilitating trust and confidence in the courts, it always starts with our people. They are the face of justice for individuals entering the court system every day. It is our goal to create a culture where people entering the courts interact with staff who are knowledgeable, caring, and helpful. We strive for people to see judges who are hardworking, take the time to hear from the parties, efficiently move cases forward, and are knowledgeable and committed to following the law. We are fortunate to have excellent judges and staff in South Dakota, and I'm proud to stand here today to talk about their good work. Last week, I began my second four-year term as Chief Justice of the South Dakota Supreme Court. At the same time, I had the pleasure of reappointing the 7 presiding circuit judges in each of our circuits in South Dakota. These judges include Cheryl Gehring, Robin Howman, Greg Stoltenberg, Mike Day, Greg McGarrah, Christina Klinger, and Robert Gazinski. They do the heavy lifting of managing staff within their courts and ensuring that cases are resolved efficiently and effectively. They are dedicated public servants, and I appreciate their commitment to the work of the courts in South Dakota. As I end today, I want to thank my colleagues, Justices Janine Kern, Mark Salter, Patty Devaney, and Scott Myron, for their confidence in me to serve another 4-year term. I also appreciate their work in leading and setting the vision for the court system in South Dakota. It is truly a joint effort. The 5 justices on the South Dakota Supreme Court bench, me and myself included, all grew up in small towns in South Dakota. We often joke that Justice Salter grew up in the metropolis of Parker, a town of about 1,000 people, as compared to Lake Andes, Mound City, Polo, and Wakanda. Some of you have been there, haven't you? All 5 of us are South Dakotans at heart. As such, we're dedicated to leading the court system worthy of the faith and trust of every South Dakotan. And I'm grateful for your support in this mission. Thank you.
I always appreciate being invited. Thank you.